Hi, everyone. Thank you so much for joining us for another IDA Motivational Monday. My name is Janet Thibault. I'm currently the Branch Council Chair, so I volunteer with IDA working with all of our 43 branches. I'm so happy to have you here today listening to us. Today's topic is advocating for students with dyslexia, a conversation with Pete Wright. I'm really excited to have Pete Wright here talking with all of you. As you know, he's a nationally known special education attorney, and we're really excited that he was able to stop by today and talk. Please also check in at our website for additional upcoming Motivational Monday sessions. Thank you to everyone who is subscribed to our YouTube channel and other channels. We hope that you're enjoying all of these webinars and finding the information really helpful. We are working to increase our subscriber numbers. So if you haven't yet, please plan to subscribe on the YouTube and like us on Facebook. Our IDA conference is coming up next month in November, so please consider registering for our virtual conference. It will be held November 13th and 14th. There will be sessions for everyone from parents to students to advocates and educators, and we hope that you'll all join us virtually for the conference. Before that, October is Dyslexia Awareness Month. Please consider making a donation to IDA's Go Red campaign. You can do that and see other information about the campaign by going to idagored.org. Please consider making a contribution, and thanks so much for your support. But now I'd like to introduce our presenter. Pete Wright is an attorney who represents children with special educational needs. In second grade, Pete himself was diagnosed with learning disabilities, including dyslexia, dysgraphia, and ADHD. He was fortunate because his learning problems were identified early. His parents obtained intensive Orton Gillingham remediation. He got to work with the amazing Diana Hanbury King, and Pete's determination to help children grew out of his own educational experiences. You can certainly learn a lot more about his background, but I don't want to make you wait any further. Thank you so much, Pete, for joining us, and I'm going to turn the microphone and the camera over to you. Thanks.
Janet, thank you so much. It's a real pleasure to be here today. It's an honor, and I'm excited. You told part of my story before I got a chance to give the whole thing, but that's what I have here. Let me share my screen. Let me confirm with you that the first page of my PowerPoint slide is. Do you see that? Is that up?
Yes,
now?
We can see it perfectly.
Perfect. Okay, let me click a couple other buttons here so I can make some things disappear on my screen. Bear with me for a moment here. Okay, so that was my next slide. Who is Pete Wright? Okay, so you kind of explained part of that, said it already. In DC public schools, kindergarten, first grade, I was basically illiterate. DC public schools told my parents that I was uneducable. And in those days, that was a legal term, which in some states meant you did not have to provide any educational services to a child who was deemed to be uneducable. So DC public schools was kind of setting the stage for that with my parents. And then fortunately, there was I had a comprehensive evaluation, educational, neurological, psychological, and they found that I had strophosymbolia and acute hyperkinetic disorder. Acute hyperkinetic disorder, that label changed over the years to minimal brain damage and minimal brain dysfunction, and now ADD, ADHD. Strophosymbolia, that now dyslexia, dysgraphia, dyscalculia. They told my parents that I was basically illiterate across the board, reading, writing, arithmetic, and spelling. And I needed to find someone who was trained in what is known as the Orton Gillingham approach to teach me how to read, write, spell, and do arithmetic. And my parents found Diana Hanbury King. She worked with me for 2 years, one-on-one after school. Her goal was not to get me to age and grade level. Her goal was to get me 2 years above age and grade level. When I was in the 6th grade, I was given a comprehensive psychological, educational, neurological, and they found that I was at the 8th grade in all domains: reading, writing, arithmetic, and spelling. So I am not your typical adult dyslexic who struggles today with reading or writing or spelling or arithmetic. I have no issues with that because I am a product of top of the line intense early intervention, very intense, from someone, Diana Hamburg King, who turned out to be one of the best in the history of the world. I went to Randolph-Macon College and then worked in the field of juvenile justice for about 10 years. And at one point in 1972, at that time, I was active with the Orton Dyslexia Society, now known as IDA, and I presented at their annual conference in '74. And there's a link to the presentation that I did about reading problems in juvenile delinquency. Then I went to law school after 10 years in juvenile justice and ended up having the Carter case before the Supreme Court. We prevailed in 1993, a 9-0 decision. Shannon Carter, child with dyslexia, and there's an article on our website that I wrote for Perspectives magazine, IDA's magazine, about 3 generations of dyslexia at the U.S. Supreme Court. The 3 generations being Shannon, my client, myself, and my tutor at the residential camp that I went to, Roger Saunders. Roger Saunders was also there when I argued the Carter case. And then there's a link to the untold story behind the Carter case, goes into behind the scenes, more information. Now, in preparation for this, I was presented with a bunch of questions that you all Janet and others wanted me to incorporate in my training today, or in my presentation today. And so the questions are right here up on screen, and I will be going through answering these questions. So when a kid's on an IEP, what should the parents do? What should the parents do if they have concerns about kids' reading, academic skills? What can parents do if the school doesn't find the kid eligible for an IEP or a 504? For parents who want to seek an out-of-district placement, private placement, such as Shannon Carter obtained, what should they do to build a strong case? What are some of the issues that still need to be addressed? How can parents and organizations like IDA work to address these? And we know that COVID-19 has had a huge impact for students with dyslexia and other needs. What are some of the key ways COVID has impacted? What can parents do about this? What's the difference between 504 diagnosis and plan or an IEP under IDEA? And is one better than the other? And what are some of the positive changes that you have seen schools find and help kids with dyslexia? Well, before answering those questions, there are some basic principles that we need to go over. Parents need to be able to understand basically special ed law and its history, how it came into being, and have to understand principles of persuasion, marketing, and selling. When I had an active practice, my parents mastered these concepts, these principles, and they also had to understand the bell curve and test data to be able to read the evaluations on the child and understand exactly what the test scores meant. And they had to be able to document this and document that and learn how to write what we refer to as the letter to the stranger. Letter is lost in the street, found by a stranger, and a stranger wants to pick up the ball and right the wrong. And the letter does not blame, attack, or finger point. Instead, it tells a story that creates empathy. So one thing that you need to be aware of, parents, you need to be aware of that parents lose good cases because of their own emotions. The emotions interfere so often with parents learning how to be effective advocates on behalf of their child, and parents' emotional response to situations oftentimes close doors, both with school officials and if a case goes into court later on with hearing officers and with judges, because of the parents' emotional response, because they want to argue what the law is and they want to argue the facts of the case. And that does not actually open doors for parents. When parents take that approach, they are taking a step toward closing doors. Parents have to be able to understand the kid's test data. For example, a kid's standard score in reading went from 90 to 70. So what does that mean? If you don't know that, when I asked this question just now, you need to learn it. You really absolutely must learn this. When parents came in to see me, typically they were furious with the school district. They were out for blood. They were angry. They felt betrayed. And my job, my role with parents, the parents to be effective advocates for their child, they had to shift. They had to create a new personality, a new persona. That one had to be one that is merged with Mrs. Manners, Peter Falk Columbo. For the older people listening, there was a TV series about Columbo, a detective. The actor was Peter Falk, and he relied on the 5 W's plus H plus E. Who, why, what, when, where, how, and explain questions. He was a master at that. And my parents had to incorporate a Mother Teresa perspective of sorts. So they had a new image. And they realized that what controls outcome are not principles of laws. In fact, what controls outcome is persuasion, their ability to persuade the person with power to give them what was needed for their child. Marketing and sales and persuasion is the key. So all of my parents, and Pam and I taught 3 semesters at William & Mary Law School for law students to help the law school get their special ed clinic up and running. And all of our law students had to read these 2 books. So my parents and my law students had to read these 2 books. One book was called Getting to Yes, and the other one's How to Argue and Win Every Time. By reading those 2 books, you learn how the opposition thinks and feels. Parents learn how to tell a narrative story in chronological order with visual imagery that creates empathy. My parents and my law students had to read both, and I drilled my parents and I drilled my law students on this. You should read these books too. They will have a profound impact on your ability to negotiate and change the emotions of the other person on the other side of the table. You change their emotional response, then you change their beliefs and their position. That's the key. This is the cover of Jerry Spence's book, and it's not about arguing and not about winning. It's about telling a story with visual imagery that impacts emotions and getting to yes. Learning how the other side feels about the problem, how they see it. When you understand this and the person on the other side knows you understand how they feel, how they see it, you are on the way toward resolution. You want the person with power, whether it's a director of special ed, whether it's the hearing officer that goes to litigation, federal court judge. You want that person to feel empathy toward your position. Parents have to understand documentation. We have a concept called the letter to the stranger that's in our books and on our website, telling a story with visual imagery in narrative chronological order. And parents will say, well, you know, they told me this and they told me that. And I will say, oh, did they put that in writing? Well, no, they didn't. Well, then it wasn't said. If it's not in writing, it was not said. So parents, you have to write a letter back to the school thanking them for clarifying for you that they're not going to be able to increase speech language services despite the recommendation of the private sector evaluation this year because there's a budget shortfall, even though everyone agrees that the child needs it. Well, technically, that would be wrong. You cannot use the finances to stand in the way. You have to put it in writing. Thank you. So we've got all of this kinds of stuff. It's in our book, From Emotions to Advocacy. In the early history of special ed law, children with special needs with disabilities were expelled from school, not because of behavioral problems, but because the school district could not afford to educate them, could not afford to put in an elevator or to put ramps up to the 2nd floor or to hire individuals to tutor the child in learning how to read. Children were deemed to be uneducable, and by state statute in some states, no responsibility to educate those children, and it was all based upon the dollar. So there was 2 big cases. One was out of Pennsylvania, Pennsylvania Association for Retarded Children, and the statute said uneducable, no education. And the court forced Pennsylvania to change that statute. And then in Washington, D.C., if a kid was taken away from his parents because he was neglected, abused, abandoned, the kid was placed into the DC Junior Village. And DC Public Schools, a sister agency, told DC Junior Village that those kids with special needs with disabilities were not allowed to attend DC Public Schools because the public schools could not afford to educate them. So a big lawsuit. And the judge, in his decision, in his ruling against DC Public Schools, made a statement that inadequate funding cannot be permitted to bear more heavily on the child with a disability. This case and the part case of what caused Congress to pass the law about what we now know today as IDEA, Children with Disabilities Education Act, Education for All Children, Education for All Handicapped Children Act of 1975 was passed because of those two cases, and the issue of funding is not a permissible defense. The early cases when the law came out had to do with whether a child was or was not eligible for an IEP, the identification, how it was determined. The courts began to find that if a kid had a disability, the mere presence of a disability did not make a child eligible for an IEP. The disability had to adversely affect educational performance such that the child needed special education and related services. And there was cases about what is an appropriate education and how that was defined. The law has, the evolution of the law has changed a bit. It's not that the law has changed, case law has changed. In the early 1980s, children in Virginia with autism were not eligible for special ed, and that was upheld by a U.S. district court. Now, that is one part of the statute that did change, because then they did put in the statute that autism was one of the identifying conditions. Our special ed law book has a complete statute, IDEA 2004, and the complete regs, and then also related portions of 504 and more. I want my parents to understand that there are 5 key statutes in IDEA. IDEA is not a difficult statute to follow or to understand. It actually is fairly easy and fairly clean. The first statute is 1400, which has the findings of Congress that cause Congress to decide to pass a law. Then the next, and then it has as a part of it the purpose of the law. Then the next part, 1401, definitions, defines what is a child with disability, defines specific learning disability, related services, supplementary aid and services, etc. Then the next is 1412, what states have to do and agree to do to be able to receive federal money. It also has the concepts of extended school year, least restrictive environment, FAPE, all of that is in 1412. And then the next statute is the critical one that most people need to have a good handle on, and that's 1414. It has all of the law of initial evaluations, law of eligibility and reevaluations, and has all of the IEP statute in there. And then 1415 has all of the rules for procedure, IEEs, independent educational evaluations, going to due process hearings, going to court, discipline. So those are the 5 key statutes: 1400, 1401, 1412, 1414, and 1415. 1414 is the key statute. When Congress passes a law, a federal law, then pursuant to the Supremacy Clause of the U.S. Constitution, that federal law, that statute, what we know as the United States Code, that rules, it is supreme. Federal regulations issued by the federal agencies, the U.S. Department of Education, or state statutes and state regulations may not take away a right provided by federal law. Because of that, it's critical to understand what the federal law says on any particular issue. Then you look at the state regulation. And so often someone will tell me, well, our state doesn't really follow the federal law. We only follow the regs, the state regulations, and that's all we pay attention to. Well, people who do that are nearsighted, because they don't realize that if that case goes up into court, the judge is going to look to the federal statute first. and then look to the federal regulations second, and then look to the state statutes and state regs. State statutes, state regs can provide more detail, more specificity, but may not take away a right provided by federal law. So whenever you're trying to find the answer to a legal question, always start with the federal statute, IDEA. Start with the United States Code first, then the regulation. So I'm going to share with you the most important statute in all of IDEA is right here. It explains that the purposes of this title are to ensure that all kids with disabilities have available to them FAPE that emphasizes special education and related services designed to meet their unique needs and prepare them for further education, employment, and independent living. So this is the key, preparing children for further education, employment, and independent living. And in subsection C under the findings, Congress talked about the children becoming economically self-sufficient. Economic self-sufficiency, preparing children for further education, employment, and independent living. So this is the mission statement of the entire law. This is what it's all about. So when you're wrestling with something, go back and look up the mission statement and figure out with the issue you have, the answer to the question, how does it relate to this? This is the key. So basically, I said in the beginning, the parents must understand special ed law and its history. We looked briefly at the history, we looked at the statute. Then I also said parents have got to read these two books, Getting to Yes and How to Argue and Win Every Time. So we have a couple more things coming up on our list of basic principles that I laid out in the beginning. In our From Emotions to Advocacy book, we have 2 chapters all about tests and measurements and the bell curve, understanding the bell curve and how to apply it. When you master the bell curve, you're going to learn about the relationship between standard scores, percentile ranks, standard deviation, the mean, the normal range. You're going to learn how to determine a percentile rank from a standard score, index score, IQ score. You're going to learn how to determine a percentile rank from a subtest score, a scale score. In other words, most important, you're going to learn about whether the child is making measurable progress, remaining flat, or worse, progressing. You have to understand and be able to apply the concept of the bell curve to answer these questions. How is a kid doing now? That's the key. Remember I said his standard score went from a 90 to a 70. Is that progress? Is that okay? Is that acceptable? Is that within normal range? I mean, should we be concerned about that or not? You'll know in just a couple of minutes. This is what the bell curve looks like. So this is 0 standard deviation. So if a kid gets a score right here, this child scored 0 standard deviations from the mean. The kid had a standard score of 100 or a subtest score of 10. That kid is at the 50th percentile rank, right smack dab in the middle. A kid who gets a score over here is 1 standard deviation above the mean. This is 2 standard deviations. This score here is 115 or a subtest score of 13, which is at the 84th percent. If a kid gets a score right here, 110, which is comparable to a subtest score of 12, that's at the 75th percentile rank. If a kid gets a score over here of 85 on the so-and-so test, that kid's score was 1 deviation below the mean at the 16th percent. So if a kid is a 90, that's 25th percent. And I said, if a kid goes from a standard score of 90 to a standard score of 70, is that okay? Do we not worry about it? Is that within acceptable limits? Well, basically, what it means is the kid was at the 25th percentile rank, this initial testing, and now is down to 70, a standard score of 70, which is the bottom 2%. The kid fell from 25th percent to 2%. You have to understand this. You have to be able to look at your child's own evaluations and understand these numbers. And this is the same thing, just in a table format. When I had an active practice, I charted out the children's test scores. That was how I always did it. And this is a case that I had way back many, many years ago. I was evaluated in January of 90 by the school district, was found eligible for special ed and for an IEP because of a learning disability in reading. Now, standard score of 97 is almost close to 100. That's almost at the 50th percentile rank. How could that be? How could he have been found eligible because of a learning disability in reading? His IQ was above 130, 99.9 percentile plus, genius, borderline genius. So that was when they used discrepancy formula for determining eligibility. He was more than 2 deviations below the mean from his intellectual IQ score and his reading, so he was found eligible. And then his score went to 94, 90 to 78. This school district loved the Woodcock Johnson, and the mother yanked him out in summer of 95 and put the child into Orton Gillingham School in Richmond, Virginia, new community school, and came to see me about getting tuition reimbursement. And my responsibility in a tuition reimbursement case is to be able to prove that the school district's IEP was not appropriate and the private program is appropriate. But I did not put my cases on that way. No, I put my cases on that the school's program, their IEP, damaged the child and the private program is appropriate. Because if I say that, if I just argue the public school program is not appropriate, that causes a hearing officer to do a balancing test. I don't want a balancing test. I want the hearing officer to be absolutely convinced that the kid was damaged. Obviously, it's not appropriate. But this table does not accomplish that objective. You can intellectually understand 97 down to 78, that's not good. But it doesn't really hit you between the eyes in the gut. It doesn't market and sell very well. So I changed the standard scores to percentile rank. So that was 42nd all the way down to 7. That is more powerful. The same information just presented as percentile ranks rather than standard scores. But still, it's a table and it doesn't market and sell. It doesn't have nice visual imagery, it doesn't hit you in the gut. And I market and sell to emotions of the person with power, their emotional response. That's what I'm looking for. Then I created a bar graph. And this actually is, I'm almost done. I then isolated each one of the items, reading, writing, arithmetic. Isolate him. Your Honor, he went to the special education program because he had a learning disability in reading, and this is what happened. This slide hit the hearing officer between the eyes. This slide just about won the case for us. This kid was really, really bright. He could solve complicated math problems in his head, and this is what happened. I'm sorry, this is what happened in math. He went from here all the way down to here. And his writing went up and down. I was perplexed by that. And I asked the mother about that. Oh, Mr. Wright, we forgot to tell you. We hired a tutor from the new community school way back, sometime in 1990 or 1991. And she worked with him for a few months on his language skills. You could not read his writing. It was illegible. The tutor was using Orton Gillingham. So I had proof already that way back years before, Orton Gillingham, when it was used for a short period of time, worked for this kid. So here's another example. I'm going to use data points. Kid was tested. Let's say the kid went into special ed, was tested, and he was at the 25th percentile rank in whatever this particular educational achievement skill was, whether it was reading, writing, arithmetic, expressive speech, receptive language, whatever. The kid was at the 25th percentile, and that was the identified area that was being targeted by the school district, was tested 3 years later at the 10th percentile rank. So how am I going to present this information? Let's assume I'm not going to use a bar graph. I'm going to make a line graph. Okay, here we have 25th percent, and we have 10%. Slow downhill slide. Would I do it like that, or would I do it like that? 25th percent, 10%. These are identical. I just brought the side margins in tighter. This was a slow downhill slide. This kid fell off the cliff and hit the bottom part. Which one marks and sells with my theme of the case that the school's program really damaged the child? So parents got to understand percent law history, persuasion, bell curve and test data, and documentation. I mentioned earlier, parents have to learn how to write what we call the letter to the stranger that has visual imagery telling a narrative story. So questions. So here are questions. Once a kid's on an IEP, what do the parents do? So I repeated the questions. I repeated that slide again where we have all the questions spelled out here. For a moment here. So here are the answers. When a kid is on an IEP, what should the parents do to make sure things are working? You've got to have test data to confirm their steady growth in the identified areas of weakness. Chart out the test data and confirm that these standard scores and the percentile ranks are going up. When I worked with parents in my theoretical approach with parents was not to do for my parents, but to empower them to be able to do things for themselves. My parents could take a blank sheet of paper and do a freehand drawing of the bell curve. They had to do it in my office. They knew I was going to test them on it. They practiced it. And so they could do it. So then when they went to a triennial evaluation meeting and were given new test data that they had asked for prior to the meeting, but were not able to get, it was given to them at the last minute, just as the meeting started. They took out a sheet of paper, did a freehand drawing of the bell curve. They had a neat organized files they brought with them. They recognized on this new testing some scores that were from, they recognized some of the tests that were given to the child previously. They then looked up the other tests in their file, logged them in on the bell curve they had just drawn freehand on a sheet of paper, and then in the new evaluation logged in those scores, and they knew if the kid had made progress, had just stayed the same, or worse, had gone downhill. Powerful stuff when you're at a meeting, because you know what's going on with your child. Parents have to stay on top of this and understand the data and where the kid is scoring on stuff. So what should parents do if they have concerns about the students' reading and academic skills? You've got to have detailed records and data. I recommend parents take video. Have video of your child. Let's assume there are issues with reading. Get some video from time to time of a kid reading out loud. How is the kid reading out loud? Be able to monitor that, and the video is powerful evidence if there is litigation down the road, or when you go to meetings with the school and they tell you that he's doing just fine, thank you, and they're so pleased with the progress, and you have video there that you can play for them to show that it really is not all that good, or whatever else it might be. And that means you've got to meet regularly with the critical staff that are working with your child. And when someone says to you, well, you know, we really would like for your son to have more time with the teacher who's working with him on acquisition of reading skills, and she's learning how to use this new approach called the Orton-Gillingham approach, but we don't have the funds right yet to assign any more students to her. And again, if it's not in writing, it wasn't said, they didn't say that to you. So you have to write a follow-up letter. And by the way, my parents were told to find an expert in Orton-Gillingham. That has been around since the 1930s. What can parents do if the school doesn't find their student eligible for an IEP or a 504? You have to look up independent educational evaluations, IEE, in IDEA, in the statute and in the regs. There's more depth about it in the regulations, and you want to see about requesting an IE, but understand how that works before you make the request. Understand all the law of IEP and the case law, not just the statute and the regulations, but the case law of that IEE, so you have the best understanding as to how to present your request to the school district. And then you want to use the school's own testing many times will actually support that the child should have been found eligible. But if you really don't understand the test scores, then it's hard for you to take that position. So you do have to understand the testing and what the scores mean. I looked at the sub-test scatter in depth. I looked very closely. Sure, I'm interested in the overall global cluster score, but more important to me is what's the spread between the subtest scores, whether it's educational achievement testing or IQ testing, between similarities and coding and what they mean and what they represent. That's where you can make your case that the kid should be eligible. And you want to learn how to use Google Scholar. And there are lots of cases out there dealing with issues of eligibility. And you can see what the courts looked at when they ruled, made a finding the kid was eligible, and what they looked at when they made a finding the child was not eligible. So go through those cases and read some of them and get a handle on how best to frame your issue. And we have every year we come out, we began in 2015, we come out with a year in review book that is all of the cases from the U.S. Courts of Appeal around the country related to special ed. And so go through some of the eligibility cases in there. And that book also has instructions on how to use Google Scholar. All right, for parents who want to seek an out-of-district placement, what should they do to build a strong case? And that's like the Shannon Carter case, where she ended up going to try to an academy or in Gillingham School down in Mount Pleasant, South Carolina, right adjacent to Charleston. When I had a tuition reimbursement case, an out-of-district placement, when a parent consulted with me about it, and we'll assume the child was still in public school and the parents wanted to get it before the fact rather than have to place the child and then sue to get reimbursed. I wanted, again, to be able to prove that the public schools program was not appropriate, that it damaged the child. And what I would do is I would have my parents obtain a private evaluator to evaluate the child, IQ testing and educational achievement testing, reading, writing, arithmetic, spelling, have a good sense of strengths and weaknesses, compare those scores to other testing you've done in the past, and then I would want my evaluator. This is your best case scenario now. I would want my private evaluator to meet with the public school staff at an IEP meeting and share the evaluation, the results, and then the public school typically would ask the private evaluator, well, take a look at our program. Our program is really, really good. We feel convinced that you'll come away with a belief that it really is good. And that many times was my private evaluator's foot in the door to eyeball the public school program. And the evaluator would then tell the parents, that program is not appropriate for your child. I understand why it's damaged your child, and you need to put your child into the private program. So I have my private evaluator taking the position private program is necessary, and my evaluator has also eyeballed the private school program. So as a witness, they can testify about the public program and the private school program. There's a case on our website, the Brody case, where the parent's letter was pivotal, and letter to the stranger was pivotal in the outcome. But my evaluators eyeballed the public school program and eyeballed the private program also, and it had a definite impact. And then parents have to be sure that they give advance notice to the school district by what we recommend is a letter to the stranger, and it must be done by law if it's in writing 10 business days prior to the kid's removal from the public school. Parents have lost cases because they failed to do that. What are some issues that still need to be addressed? How can parents and organizations like IDA work to address these? The biggest issue, I think, right now in the public schools is that teachers don't know how to teach kids how to read. Teacher preparation is absolutely a major issue. I had a case in Upper Arlington, Ohio, called the Joseph James case. He had attended Kildonan School. Diana Henry King worked with him, and the parents wanted to put him back in the public school, and he had reading recovery before he left the public school, before he went to Kildonan, and was our position that damaged him. There was a parents group in Upper Arlington, Ohio, that ended up creating a 44-minute video and a downloadable PDF manual about creating change within their school district. So what happened? I had my case 10 years, a few years later, the school district backslid, and these parents learned about my case, the James case. They went after the school district. They filed complaints against the school district. The school district now is the best school district I know of in the country in terms of teaching children with dyslexia how to read. All of these special ed staff are Orton, Gillingham trained. The other big issue that's out there is so many school districts around the country have an aversion to identifying a child as having dyslexia, and yet it's been in the statute since 1975. More about Upper Arlington. That was the birthplace of reading recovery, defended by Joseph James, and all teachers are trained in Horton Gillingham. And there's a video all about their success, was released earlier this year. The whole story, it's located, the website is called Our Dyslexic Children. That's a cover of the, it's a 44-minute video, and they have created a manual. I'll get to that in just a moment. COVID has had a huge impact, yes. What are some of the key ways COVID has impacted their schooling? What's happening is our kids are losing skills. I mean, it's just sad. It's not good for our kids. In addition to losing skills, socialization, interaction with peers has suffered. Kids are becoming depressed. They're becoming withdrawn, and I don't have much of an answer what to do about the kids becoming depressed and withdrawn. But in terms of skills, there are things that can be done in that regard. For the educational skills, you can request the school district provide your child with compensatory aid and extend the school year. Parents may also want to consider hiring a tutor at this point, or even becoming a qualified tutor for their child. I've had some of my parents in the past years who ended up taking Horton Gillingham training and becoming tutors for their child. Before requesting services such as Comp Ed or ESY, parents have really got to understand the case law about Comp Ed. The U.S. Department of Education has issued a number of position statements that are actually favorable to our kids with the matter of Comp Ed and ESY. They are on our website. We've got an entire directory on our website that has a number of PDF files, that number of documents that have been issued by the feds and also by state agencies and other organizations. And they are located wrightslaw.com/COVID, and also Comp Ed is info/COVID. And the links to these and more are on our main page. So if you go to the main Wright's Law page, you'll find links to all these documents. If you want to use the Department of Ed, the U.S. Department of Ed's documents to support your case, they've given you the ammunition. You have to use it in the right way, and in a way that you don't end up causing litigation, but instead opening doors to services for your child. So what's the difference between a 504 diagnosis, 504 plan versus an IEP under IDEA? Is one better than the other? For a child under IDEA to be eligible for an IEP, the kid's disability must adversely affect educational performance such that the child needs special education and related services. That's in our law book. A child with a disability the disability does not adversely affect educational performance, such that the child does not need special ed related services, is not eligible for an IEP, but is typically eligible for a 504 plan because the kid has a disability. So what is best? Which one is best? There are a lot of different factors that impact which one is best. In some of my cases and some of my clients in the past, an IEP was preferred. In others, no, not an IEP. A 504 plan was more appropriate. 504, the protections of 504 apply to all kids with IEPs. Kids with disabilities who have IEPs are also eligible for all the protections of 504. But IDEA IEPs do not apply to kids who only have 504 plans. This is also impacted by the reality of what is and is not available in any given school district. In some school districts, you may be better off going with 504 because what they're doing with the 504 kids with regard to teaching them how to read may well be better than what they're doing with the IEP kids. What I find so often with Wright child with dyslexia under an IEP, everyone lowers their expectations and they don't hold the kid up to higher standards. Instead, rather than teaching the child how to read, they shift to providing modifications and accommodations using talking textbooks, lowering the bar, and they don't focus on teaching the child how to read. And that's the key. Your kids got to learn how to read. What are some of the positive changes you've seen with kids? How schools find and help kids with dyslexia? Decoding dyslexia in groups like those in Upper Arlington, Ohio, have caused educators to reassess their approach to teaching children how to read. Journalists such as Emily Hanford, publications such as Education Week have created an increased awareness that our schools are failing in the education of kids with dyslexia. Many state legislative bodies have enacted state statutes that define dyslexia using IDA's definition and have mandated teacher preparation regarding dyslexia. Case law is evolving in the U.S. Supreme Court and U.S. Courts of Appeals. It is moving forward in a pro-child direction now. 2017 were two pro-child unanimous cases from the U.S. Supreme Court. One of them is the NUF case, and in that, Chief Justice Roberts talked about taking a look at the child's potential as a part of the development of the IEP. And immediately within a week, the Ninth Circuit, in a case called Antelope Valley, fantastic case, picked up on that and addressed use of potential. We are seeing a positive movement in case law now. I'm feeling very good about it. Putting it together, again, emotions interfere with parents being able to get services. Parents have to understand conflict is normal and inevitable. They must keep their emotions under control. If you're working with parents, you want to help them identify the obstacles and help them seek win-win solutions for problems, the getting to yes approach. And you want to help the parent master the art of documentation, and most important, writing what we refer to as the letter to the stranger. And I have 13 minutes, so now I am going to shift back and I am going to stop share. And I am now back full screen. And I know that you wanted some time set aside here in the end to perhaps ask me some additional questions. I may have triggered some things that maybe caught you by surprise. So I open the mic up to everyone else.
Thanks so much, Pete. And I'm really grateful for all of the wonderful information that you provided. I do have a couple of follow-up questions, if that's okay. When parents are working with a young child, especially where the school district is saying, well, you know, it's really developmental to not be able to read at this age, what can parents do with those young children who are obviously struggling and the parents have concerns and the district may not be ready yet to acknowledge those challenges?
That happens too often, sad to say, and that's wrong. You know, if that had happened with me, I hate to think, what if I had been found eligible for an IEP, 10, 15 years ago? I wouldn't have had the intense one-on-one from Diana King, almost 2 years of Orton Gillingham, and by the 6th grade reading at the 8th grade level. Would not have happened. I really am troubled so much by what's happening now compared to how it was earlier. So I tell parents when parents are told, well, you know, your expectations are too high. Yeah, all children have difficulty learning how to read. So you're jumping the gun, and up to the 3rd grade, children learn how to read. From 3rd grade on, they read in order to learn. And if you look at the 3rd grade, it's when all the behavioral problems start, and that's the key to me when I'm reviewing files. So parents have got to educate that person with power that no, that's not the way that it goes. When way back, I have 2 boys. Both of my boys had LD issues. And I had an instance one time when a teacher had just kind of put a line in the sand and a roadblock. And she was dead wrong. I knew she was wrong, but I couldn't tell her because I knew if I just hit her head on, that would have put the walls up and I would have closed the door to my child. So I went in to her and I played the dummy. My parents were really good at playing the dummy. I went in and played the dummy, and I said, I am so confused because um, you told me this and you told me that about my child, and I was talking with a good friend of ours. We got together this weekend with, and I gave a person's name who's a special ed teacher in so and so county, and we've been friends with her for years. And she told me that there's some real issues going on with my son, and she uh, uh, and I told her what was going on at school with you, and she said, "Well, here, hold on." She went out to her car. I'm talking to the teacher, public school teacher now. She went to her car and got her textbook, Janet Lerner's textbook about learning disabilities. Literally, it was Janet Lerner's book, and so I showed it to this teacher. I said, Janet Lerner says right here, and she told me to share this with you. And I don't understand what it means because you're the expert. So here, I'm going to leave this book with you. I got to get it back to her next week. So I'm going to leave this with you for a few days, and I'll get it back from you. But help me understand what we need to do. And that way, I sidestep her getting into a battle with me, my telling her she's doing it wrong. I instead said, you help me understand what this lady, Dr. Lerner, is talking about because it's Greek to me and this is your area. So the teachers turned around. Then I got with her a couple of days later. She says, this is what it means. And she educated me in essence what Janet Lerner was saying. And she also told me how she was going to make changes with my son's program and what she was doing. She, the teacher, did not know at that time that I was a special ed lawyer suing school systems at all. She had no knowledge about that. Thank goodness. And I saw her a couple of years later. And, Mr. Wright, you snookered me when you came and talked to me about your son. I didn't know who you were then. We had a good laugh about it. So the parents got to think smart. You can't go in, go straight up because you close the door. But you've got to educate that person who doesn't know in a way that doesn't make them defensive. Not easy. Marketing and sales. You want the person to buy that product and they don't need it.
I have another question. How did you decide to get into becoming a special education lawyer to begin with?
It just evolved naturally. I worked juvenile justice almost 10 years, and I was a member. I became a member in 1972 of the Orton Dyslexia Society, now the International Dyslexia Association, because of Mary Louise Truesdale and another individual, Richmond City Public Schools, Stonewall Jackson, who Richmond, Virginia had an Orton Gillingham school in the 70s. Public school was Orton Gillingham. And there were several people there. And so one of my kids had dyslexia. And I was talking with one of the teachers there about one of my kids that I had on probation. And then she was telling me about this and about that. And I said to her, I have dyslexia too. And the lady said, oh yeah, well, lots of people have problems with reading. It doesn't mean you have dyslexia. And I could tell she didn't believe me. And I said, no, I read it. Diana Hamburger King tutored me for 2 years. Oh, you have dyslexia. She's a good. And so that was just before going to law school. So when I went to law school, of course, then the law was in process. It was passed in 1975 while I was in law school. So it just naturally happened. When I got out of law school, I began doing juvenile delinquency cases and special ed, and been doing it ever since.
Any words of wisdom in terms of an organization like IDA and what we could be doing to help make a more significant change in the landscape for students with dyslexia?
Wow. Big question. No easy answers. As Sally Smith used to say, no easy answers. Instead, Decoding Dyslexia has done an incredible job. In some parts of the country, they are very, very strong, have really changed things. The key is getting state legislators involved. And with the state legislators, I have found you find a grandparent who's got a kid with special needs, and that's the key. Find out who that person is, whether it's autism, dyslexia, whatever. Those are the ones that will take the lead so many times. And I've been involved in, I've had a number of instances where legislators at the state level have contacted me and asked me to support this, or how should they opt for this, or whatever else. And those are the ones that, so part of it's getting involved in the legislative body, getting the state departments of education to really initiate a real thrust and focus on dyslexia, not being afraid of the word, and the structured literacy program that Orton International, I want to call you all Orton Dyslexia, but International Dyslexia Association now is supporting. So I think it's working with these people that are down in the trenches, and the group out in Upper Arlington, Ohio that I mentioned. What they've done is masterful, and this video is very powerful. And they've created a whole manual, a workbook for the parent in the street to get their school district to create change as they did. I mean, that school district went from my suing them because it was a reading recovery focus to then agreeing to make a change and making a change for a while and then going back downhill. And then this parent group filed complaints. 10 years later, they learned about my case and they filed complaints and they turned around at the school district to a 180-degree shift. And it's awesome. And I think kind of banding together and helping get that word spread on how to do it. They did it. And they have all this, they had the support of the school district, the parents group, and it's a joint project with the parents and the school district now.
Do you see more cases like that one? We recently screened the movie that they made about their efforts, and I think that it really took a group of parents banding together and suing the district like you described. Do you see more groups of parents looking to make that sort of change and go through that legal process?
Oh, they're out there. Oh, yes. Yeah, they're out there. It's not that I've seen an increase in them, but there's no question they're out there. They just need to be kind of hooked up together. And that's one of the benefits now. I don't really care for Facebook myself. I try to stay away from it by and large, but it's things like Facebook that do get them get banded together. And what they did up in decoding dyslexia really kind of evolved out of New Jersey. And I got to know that there were a couple two people who are primarily involved. And I got to know one of them and what they how they marshaled everything together and how it just spread. And that movement has to keep going. It's not going as fast as it was going before because it really went hard charging. But we can't people can't rest now. We still got to keep pushing forward, and it's moving forward steadily. There's no question about it, and just keeping that going. So I think with IDA working together with.
We are just about out of time. Thank you so much for joining us today. It was a pleasure hearing all of the information that you provided.
I hope I didn't swamp everybody with too much too fast. But it's kind of like you got to touch on this, touch on that, and give people the exposure. So then if they want to go out and do their own homework, now they know what to do. Thank you very much for having me. I enjoyed it.
No, that overview was really helpful. And I'm just going to take a few minutes now to close up and thank everyone for joining us. Remind everyone to please consider giving to the IDA Go Red campaign, to join us for our virtual conference in November, and subscribe and like us on social media. Thank you again for joining us. We look forward to welcoming you to more Motivational Mondays. And again, thanks to Pete Wright for joining us today with a lot of really great information. Take care, everyone. It was a pleasure.